رب العالمين وأفضل الصلاة وأتم التسليم على سيدنا ونبينا محمد وعلى آله وأصحابه وأتباعه إلى يوم الدين. اللهم فقهنا في الدين وعلمنا التأويل وألهمنا رشدنا يا رب العالمين. Alhamdulillah. In our lessons on Maraqi al-Falah, Sharh Nur al-Idah, we are looking at the prayer of the sick. And we reached the words of Imam Ashrun Bulali rahimahullah ta'ala, وَإِن قَدَرَ عَلَى الْقِيَامِ وَعَجَزَ عَنِ الرُّكُوعِ وَالسُّجُودِ. If one is able to stand, however, one is unable to bow and prostrate, صَلَّ قَاعِدًا بِالْإِيمَاءِ, then one prays seated with head movements. Right? So basically, if you're not able to prostrate, it is better to pray sitting on the ground than it is to pray standing with head movements. Right? So if you can't prostrate, right, إذا سقط السجود سقط القيام. When you cannot prostrate, you don't need to stand. Right? وَهُوَ أَفْضَلُ مِنْ إِيمَائِهِ قَائِمًا. And وَهُوَ أي القعود, and this meaning praying sitting with head movements, sitting down meaning on the ground with head movements. أفضل من إيمائه قائما. This is better than praying with head movements standing. Why? لقربه من السجود. Because this is closer to prostration. That is the soul of the prayer. Right? Right? That's why even in the Dur it says لِقُرْبِهِ مِنَ الْأَرْضِ, right? Because of it's closer to the ground, so it's closer to the state of prostration, right? وَيَسْقُطُ الرُّكُوعُ عَمَّنْ عَجَزَ عَنِ السُّجُودِ. And the ruku' is lifted from the one unable to prostrate. وَإِن قَدَرَ عَلَى الرُّكُوعِ. Even if one is able to do a ruku', meaning one is able to do the full ruku'. لأن القيام وسيلة إلى السجود. Because the standing is a means to the prostration. Right? فإذا فات المقصود بالذات لا يجب ما دونه. So if what is sought in itself is lifted, then that which is less than it, meaning what is less than it? What is what's meant by ما دونه? أي السجود القيام الذي هو وسيلة, right? 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 The standing, which is a means, right? Right? لا يجب ما دونه أي القيام الذي هو وسيلة إلى السجود. And of course, this is the reasoning. Textually, it is established. It is established that, so there's several things, right? That okay, when the Prophet ﷺ, at the end of his days, when he was praying with head movements, how was he praying? Seated on the ground, right? And there's multiple athar that confirm that as well. You can find that in So this is not just a rationally established matter, right? This is the reasoning underlying it. There's the textual direction of what are the hadith and athar that point towards this, or that affirm this. Okay. وإذا استمسك عذره بالقعود ويسيل بالقيام أو يستمسك بالإيماء ويسيل بالسجود ترك القيام والسجود وصلى قاعدا وموميا. If someone has a chronic excuse, al-udhr, right? What does it refer to? Like the excuse, meaning the chronic excuse, right? If their excuse would stop, right, would be restrained by sitting, but the excuse would flow, meaning appear by standing, then one sits. Or if one's excuse would be prevented, would literally be restrained by head movements, and would be manifest if one did a full prostration, then one would leave the standing in the first issue and pray sitting down. And the prostration, and one would pray either seated with prostration or with head movements, right? Because the basic principle is, and we took this, يجب رد العذر بقدر الإمكان. Right? يجب رد العذر بقدر الإمكان. Others said بالقدر الممكن, right? Right? It is necessary to ward off excuses, to the extent reasonably possible, right? ولو عجز عن القيام بخروجه للجماعة وقدر عليه في بيته اختلف الترجيح. And if one is incapable of standing if they headed out to the congregation, but would be able to stand if they remained at home, the ulama differed, right? And the fatwa position is, if true, right, the mufti would be wary of just accepting a claim like this. If true, then it's superior to pray standing at home, right? And al-Tahtawi quotes this from al-Bahr al-Ra'iq. And if you are able to pray standing at home with a congregation, then there's no khilaf to begin with. وإن افتتح صلاته صحيحا وعرض له مرض فيها يتمها بما قدر ولو أتمها بالإماء في المشهور وهو الصحيح لأن أداء بعضها بالركوع والسجود أولى من الإبطال وأدائها كلها بعده بالإماء. If one began the prayer fully able and then sickness overcame them, then one completes the prayer with what they're able. لا يكلف الله نفسا إلا وسعها. Allah only makes a soul responsible to the extent of its capacity. Even if they complete the prayer with head movements, according to the prevalent opinion, the mashhur opinion, right? And وهو الصحيح, and this is the sound opinion, because completing some of the prayer with actual bowing and actual prostration is superior than to break the prayer, which you're not supposed to do unless there's an unavoidable need, because الشروع ملزم والإتمام واجب, because beginning makes it incumbent to close, right? والشروع ملزم, beginning something makes it incumbent, and completing it is wajib. This is superior, and then breaking the prayer and performing all the prayer with head movements. ولو صلى المريض قاعدا يركع ويسجد فصح بنى لأن البناء كالاقتداء فيصح عندهما خلافا لمحمد. If the sick person prays sitting down with i.e. with actual bowing and prostration, and then they feel better. فصح, feel better. What is meant by صح? A قدر على القيام. Right? They're able to stand. They can build on that prayer. They can continue. And the textual reason is that the Prophet ﷺ led them sitting down while they were standing. And the Sahaba prayed behind the one sitting down while they were standing. Sitting down meaning sitting with قاعدا, with actual sujood. Right? So that is valid. But praying behind someone in ima, praying with head movements, is not valid. So from that it is understood, and other textual evidence and underlying legal reasoning, that the ima is a hala da'ifa. Qu'ud is a halat kamal, and the qiyam is akmal. Right? But you right? Qiyam is the qiyam is akmal, but you're not allowed qu'ud except with a permitting excuse. But they're both states of completeness. Therefore, this applies, right? That if you're praying with qu'ud and now you're able to stand, you can continue. لأن البناء كالاقتداء, because building on your prayer is like following. What does that mean? That فما صح فيه البناء صح فيه يعني ما صح فيه الاقتداء صح فيه البناء. In the states in which you could follow behind another in the lesser state, it is permitted to build upon it likewise. So just as someone praying sitting, you could pray behind them standing, then if you yourself were praying sitting, you could then build upon it standing. Right? That could the standing person pray behind the person praying with qu'ud? Yes, you can make iqtida. يصح اقتداء قائم بقاعد. The following of one standing is valid behind someone sitting on the ground praying with prostration. Therefore, you yourself, if you could build your prayer on someone else's prayer sitting down, then if you were sitting down, you could build your own prayer standing upon what you'd prayed previously sitting down. So things like this you should unpack. Right? لأن البناء كالاقتداء. So building on your own prayer is like praying behind someone else. How? In the way described. So it's valid according to them, meaning Abu Hanifa and Abu Yusuf, خلافا لمحمد, contrary to Imam Muhammad. وفي قوله صلى إشارة إلى أنه لو قدر قبل الركوع والسجود بنى اتفاقا. Right? And in his saying, if one prayed, there's an indication that if one became able to pray fully before bowing and prostration, then one can build on that by agreement. Because you're only really praying with head movements with qu'ud if you've, after you've done some of the prayer with in a state of qud, because otherwise you've done a full qiyam. Because the minimum rukun is a moment. So you did the rukun of qiyam, you just missed some of it. لعدم بناء القوي على الضعيف, because this is not a case of building the strong on the weak, even according to Imam Muhammad al-Hasan. You don't have to worry too much about this right now. Those interested in the reasoning of Imam Muhammad al-Hasan, etc., that comes up in the books of the khilaf between the madhab, and that helps us understand the legal reasoning. Even like things like the Jawhar al-Nayyira, etc., go into that, and many other books. ولو كان قد أدى بعضها موميا فقدر على الركوع والسجود ولو قاعدا لا يبني لما فيه من بناء القوي على الضعيف. And if one had performed some of the prayer with head movements, which would be manifest once one did a ruku' and sujood, for example, and then became able to perform an actual ruku', an actual sujood, and it's manifest primarily with the sujood, right? Even if you were praying with, sitting down, then one cannot build on having prayed with head movements, because that is then actually building a strong prayer, which is a prayer in which you are able to stand, on a weak prayer, which is a prayer which you are performing with mere head movements. وكذا يستأنف من قدر على القعود للإيماء وكان يومئ مضطجعا على المختار. And likewise, one starts over if you became able to pray sitting after previously only having been able to pray lying on one's back, according to the chosen opinion. There's a weaker opinion that it will be valid, but that's khilaf al-mukhtar. The sound opinion is, because the hadith of the Prophet primarily talks about, the pray with head movements, and it's a pray sitting with head movements. And then the other athar mention, and if you're not able to sit, then lie down, right? And this is the chosen opinion. ومن جن نسأل الله العافية بآفة سماوية أو أغمي عليه ولو بفزع من سبع أو آدمي واستمر به 5 صلوات قضى تلك الصلوات ولو كانت أكثر بأن خرج وقت السادسة لا يقضي ما فاته. كذا عن ابن عمر رضي الله تعالى عنهما في الإغماء والجنون مثله في الصحيح. If someone loses their sanity بآفة سماوية, due to a matter out of their own hands, as opposed to being something that is ascribed to their action, in which case there is no qada, there is no lifting of qada, right? بآفة سماوية would be, for example, if someone had loss of intellect through drinking wine, or they took drugs that caused them to lose sanity, they have to make up those prayers. Someone induced a state of junoon, of loss of intellect due to intoxicants, etc. All those prayers have to be made up. But if they junna, right, they lost their sanity, nasallallahu al-afiyah, or they lost consciousness, even if it is due to faza, being scared by a predatory animal or a human, and this lasts 5 prayers, right? And it needs to last that time, the time of 5 prayers. They must make up those prayers, up to 5 prayers. And if it's more than that, such that the time of the sixth prayer goes out, right? Then they don't have to make it up. They don't have to make up what they missed. And that's what's related from Abdullah ibn Umar radiallahu ta'ala anhu. It's in the Musannaf. With respect to loss of consciousness, and loss of sanity is akin to it. But it's, loss of sanity is higher than loss of consciousness, right? And of course, this does not apply to sleep. Right? وليس كذلك في النوم الممتد, right? And this is not the ruling of, because هذا نادر لا يبنى عليه حكم. That's rare, and a ruling is not built upon the rare cases, right? Normally people don't sleep a whole day, and if it happens, it's rare. And now if it becomes a chronic condition, that's a separate matter. And there's some nice discussion about junoon and the different types of junoon. Tahtawi quotes it from al-Haddadi, the author of al-Jawhar al-Nayra. So this is the section on sickness, right? Then he says, في إسقاط الصلاة والصوم, in the lifting of prayer and fasting. But before we continue, any questions here? Go ahead.
Where he says, وَلَوْ كَانَ مُومِيًا لا. In this situation, does this person finish the prayer and then repeat it?
How would they finish their prayer?
If they were praying with Iman, and they finish Iman, and do they repeat them?
Why? Because if so someone's praying, so best to turn it into a question, right? If someone is praying with head movements, and then they're able to pray standing, then they can't continue. May have swallowed it flat. So, if someone's praying with head movements, now they're able to stand. التكليف بقدر الوسع, more responsibility, extent of ability. If you're able to stand, can you avoid standing in the fard? لا. So there, you make salam للقطع, and you يستأنف, you start again.
So, I'm asking about din al-bina al-ibtida'i for. So, let's say somebody is seated, praying with head movements because they have a condition that causes gas to escape if they were to stand or sit. And then they take medicine before the prayer, which settles that, but one of the side effects is that it causes urine to escape if they're standing or prostrating. So in that case, if they're praying seated with head movements, and the first excuse ends, and the second one starts, can they do bina of that? Because a person with an udhr is not allowed to lead another person with a different udhr. In this case, the first half of their prayer, they're praying seated with head movements because of being unable to hold in their gas, and the second half because they're unable to hold in their urine.
But they still have the first excuse.
No, that one disappears and the second one comes in.
And they made a wudu of sahib al-a'dar.
Sure. Oh wait, no, then okay. Let's say it's only when they're praying, standing, and seated.
No, so write down that question. That's very confusing.
Okay, Assalamu alaikum.
Wa
I
alaikum
have a
assalam.
question about the last sentence that we read, that the Ighma and Junoon are alike when it comes to making up prayers.
Yeah.
I'm just wondering if there's like different opinions within the same madhab? Because if I recall correctly, we've taken before that for Junoon, we don't have to make up the prayer even if it's less than 5 prayers, even if it's 1 prayer time. Or am I mixing up things?
So the asl of the question is good, in that we've taken this ruling before, right? In a different, which is where? But what does that relate to? Right? So this is this is almost like a tamheed, a preparation for the issue of isqat as-sawm, because we've taken the issue, right? And he went into at length that right, that but that's different, right? That's slightly different, right? That is in ta'azzar al-ima, right? Someone is conscious and unable to, they're conscious and they're morally responsible, but they're unable to pray with head movements. That's the issue that we took previously. They're conscious yet unable to pray even with head movements. So there's the issue of ta'khir mutlaqan, which is the opinion of some, including the author of the Hidayah in the Hidayah. And the other is that if it lasts more than 6 prayers, then qada is not required. And we took that already. Here, the issue is loss of consciousness. The other, they're conscious but unable. Here, it's loss of consciousness. So basically, loss of consciousness is like the situation of inability to. Now, Junoon is of various kinds. So Imam Tahtawi mentioned, right, that one is the case of the Junoon al-Mutbiq, the ongoing loss of sanity, which is that lasts. And they have many different scenarios of al-Junoon al-Mutbiq. Because someone could just not have sanity. Nasallallahu al-afiyah, right? Someone, they lost their sanity when they're 7 and it never came back. Right? So there's no question of qada anyway, because they're not responsible to begin with. That's one kind. So there's complete. And at some point, some people's condition can change. Right? But the other is Junoon that lasts, that extends and stops. And there they the definition of al-Junoon al-Mutbiq differs according to what it relates to. So al-Junoon al-Mutbiq, loss of sanity that lasts, is with respect to the prayer, is if it lasts 6 prayers or more, as defined here. For fasting, al-Junoon al-Mutbiq is if it lasts more than a month. For responsibility for zakat, if it lasts the whole year, then they're not responsible that year, right? And there's other opinions related to that. But loss of, go ahead.
For the one able to sit and pray with head movements, laying down is not sufficient for them. So I was wondering, what is the fossil specifically between sitting and laying down? How much leaning back?
I mean, sitting is that which is considered sitting, and lying down is that which is considered lying down. And وَمَا قَرُبَ مِنَ الشَّيْء أُعْطِيَ مِنْ حُكْمِهِ. That which is closer to a matter takes off its rulings. So if you're closer to sitting, you're considered seated. Or Yeah. So and there's multiple tafsir of this, right? Like if you look, they define it in various ways, right? But the asl is that sitting is that which is considered sitting, and lying down is that which is considered lying down. And of course one can also lie down not only due to inability but due to medical conditions as well, right? And if you look in Hashid ibn Adin page 513, it says, for example, أمره الطبيب بالاستلقاء لبزغ الماء من عينه صلى بالإمام. If a reliable doctor told one to lie down due to ongoing liquid coming out of their eyes, i.e. for it to heal, then one can pray with head movements. And the reasoning is very interesting. It says لأن حرمة الأعضاء كحرمة النفس, because the sanctity of every part of the human being is like the sanctity of their entirety. There's also another fara' that's very useful. It's also in the dur. That's why it is the dur. It says maridun tahtahu thiyabun najisa, a sick person under whom there's cloth that becomes filthy. كلما بسط شيئا تنجس من ساعته. Every time one replaces it and puts clean cloth, right, like bed sheets for example, it becomes filthy again. Meaning that in the time to replace it and pray, by the time you end the prayer, the amount of najasa on the sheets would be more than the excused amount. One can pray directly on the filth, and likewise on one's clothing, right? If more than the excused amount of filth comes. The other consideration is إلا أنه يلحقه مشقة بتحريكه, unless if you're able to change it, but by doing so there would be undue hardship for the person, that also excuses one from changing the bed sheets. And of course a person is able with their own ability, right? And that's quite useful, right, for people who are sick, they're bedridden, etc., right? Because it's mercy for them, and it's also mercy for those taking care of them. That if someone has some condition, they get whatever, you have a chronic excuse of whatever kind, and if they have to change the sheets for 5 prayers, and bed sheets are big, it becomes very, very difficult. So there's that is mercy. Okay. Is it directly related? Go ahead.
If someone has an excuse that which they pray with iman, but it's time limited, and they know due to experience that if they delay their prayer, that their excuse will be lifted, they'll have to pray their makruh time. Should they delay or should they pray with iman at an earlier time?
So they have a chronic excuse?
If they know due to experience that it's only like 30 minutes, for example.
So what's the question?
So should they delay their prayer till when they know that they'll be able to pray the prayer completely, or but it would be in a makruh time? Or should
No, but makruh, what do you mean by makruh time?
Like, for example, the last 10 minutes possible.
Oh, then that's easy, because you don't have to wait to the makruh tahrim and time. That's sort of taking the issue out of the equation, right? Like they're already a person who has an excuse. You don't have to then wait to the makruh tahrim and time. The issue would be if you're able now and you think it's Dhuhr time, you're able now, and half an hour from now you think I'll be much better in half an hour. Do you have to wait or not? There are two opinions. One is that no, because at this moment, are you able to pray standing? No. Are you sure that you're going to be able to pray standing in half an hour? No. Right? So there's leeway, and you know you're going to live for the next half hour, right? And in difficult situations, that's much safer, to be honest, right? Because in many situations, like someone's praying with head movements, they're weak, they lose consciousness, 101 things happen. You're on a flight, it's in descent and Fajr time comes in. So you can't get up. It's okay, when we get down, I'll pray. I even won Sheikh Yahya around for that, at least while he was with me. That just pray. This is all you can do right now. How do you know? How do you know we're not going to crash? How do you know you're going to survive? How do you know whether we're going to be able to pray once we get down? Because they herd people like sheep towards the exits. Then where are you going to pray? And when you're ground, you can't pray standing or sitting down or whatever. You got to pray on the ground. Once the plane lands and it stopped, now what excuse do you have to pray sitting on the ground? You pray with head movements. The plane is coming down like this. It's a udhr samawi. I mean, literally samawi. So, right? Okay. So, but one can find texts related to that. First thing to do is to define it well as a question, right? Write it out, and then one can dig for a very specific text related to it. Okay, فصل في إسقاط الصلاة والصوم. The section on lifting what was due of prayer and fasting. إذا مات المريض ولم يقدر على أداء الصلاة بالإيماء برأسه لا يلزمه الإيصاء بها وإن قلت. If a sick person died and they had been in a state of inability to perform their prayer with head movements, right? They do not need to make a wasiyah, to leave in their bequest, to expiate biha, ay بالكفارة عنها, right? Right? Mean biha ay بالكفارة عنها, to expiate for it. وإن قلت, even if it be a little. Right? بنقصها عن صلاة يوم وليلة, by it being less than the prayer of a day or night. لما روينا, because of what we have transmitted. Right? And what is it that they have transmitted? Right? Right, from the hadith of the Prophet ﷺ, that he mentioned about that if they're not able, then Allah knows their excuse better. لعدم قدرته على القضاء بالإدراك, because they're unable to make it up after having time of inability, a time of ability afterwards. Just like in fasting. What does Allah subhanahu wa ta'ala say? فَعِدَّةٌ مِّنْ أَيَّامٍ أُخَرٍ, right? Then the like of them of days after it. But the person wasn't alive for a time. Please, it's mixed with my leg. Can we just put it through the, please? It's getting tangled up. بإدراك زمن له على قول من يفسر قبول العذر بجواز التأخير ومن فسره بالسقوط ظاهر. This is according to those who explained that the acceptance of excuse, meaning in the hadith, فالله أحق بقبول العذر منه. Allah is more deserving of accepting their excuse than they are, right? That some explained Allah accepting their excuse, meaning that when unable, you can delay making it up until you're able. And the others explained it that if it lasts beyond a day, it's lifted from you. But under both, if you're not able and you died in a state of inability, then there's nothing to leave a wasiyah for to begin with. Right? Someone got in a car crash and they were paralyzed, but they're conscious for 4 days, and they died. There's no wasiyah to give. Unless they want to give it out of istihbab, then that's a separate matter, right? If it lasted 4 prayers, same thing, there's no wasiyah to give. وَكَذَا حُكْمُ الصَّوْمِ فِي شَهْرِ رَمَضَانِ. And likewise is the ruling of fasting in the month of Ramadan. إن أفطر فيه المسافر والمريض وماتا قبل الإقامة للمسافر وقبل الصحة للمريض لعدم إدراكهما عدة من أيام أخر. In Ramadan, if the traveling person didn't fast or the sick person didn't fast and they died before becoming resident for the traveler and before health for the sick person, because they did not experience a like number of days, meaning in which they were able to make up what they missed, so they don't have to leave a bequest to make kafara of those days. وَلَزِمَ عَلَيْهِ يعني على من أفطر في رمضان ولو بغير عذر الوصية بما أي بفدية ما قدر عليه. And the person, meaning the one who broke the fast in Ramadan, even if without an excuse, they would have to give a wasiyah, leave in their bequest, with a fidya, with an expiation for what they were able to perform. So someone was sick for 7 days that they didn't fast, and then they were well afterwards for 3 days, then they only have to make wasiyah for the number of days that they were able after being sick. Right? من إدراك عدة من أيام أخر, of catching the like number of equivalent days in which they were well. إن أفطر بعذر, if they broke their fast with an excuse. وإن لم يدرك عدة من أيام أخر إن أفطر بدون عذر لزمه بجميع ما أفطر. Right? And right? And if they broke their fast without excuse, then they have to leave a bequest for all the days that they broke the fast. Such as what? What would the scenario be of that?
Somebody who doesn't fast because of work.
For example, they broke the fast. Today I have work, today I have meetings, today I have this. Then those days you have to make a bequest for, because you broke the fast, but not out of an excuse, right? لأن التقصير منه, because the shortcoming was from then. لكنه يرجى له العفو بفضل الله تعالى بفدية ما لزمه. But it is hoped, and this is important, right? The fidya is not like for like. Someone can't just miss the prayers and say, I'll do the fidya. The fidya, it is hoped by the bounty of Allah that the fidya be a means for Allah's afu, of His overlooking. وَبَقِيَ بِذِمَّتِهِ. Right? And it remains in their dhimma. حتى أدركه الموت من صوم فرض وكفارة وظهار وجناية على الإحرام ومنذور. And it remains in their dhimma, right? Until they die of the fard fast and the kafara and the dhihar, the kafara and the dhihar and the transgressions against the ihram and the kafara of the nadhr, and these all come in their respective places. فَيُخْرِجُ وَلِيُّهُ, right? So then so the person themselves is responsible for putting this in their living will, right? Putting this in their living will, right? Number one. And if they do, then فَيُخْرِجُ عَنْهُ وَلِيُّهُ. And if they do so, if the person themselves, they were morally responsible to put this in their will. With the other things they put in their will. And we did a seminar on the living will last year. And very often those kinds of seminars, students of knowledge skip them and then they don't know anything about living wills. That's just their, then their wali, their guardian, meaning أي من له التصرف في ماله لوراثة أو وصاية, meaning the one who has the responsibility of discharging their estate, whether because they are one of the inheritors or because they were appointed, their wasaya, they say, okay, I've appointed so and so to discharge my inheritance. And that's something that one should put in one's contract, in one's will, to appoint somebody, and people hardly ever do it. Like, I've been teaching about this for years, and then who actually does it? Right? And the Prophet ﷺ said it's one of the first knowledges that will disappear in the ummah. The ulama explained that it's not only disappear, that people will know about the ahkam of fara'id and wasiyya and so on, that there always remain people who know how to do it. But it's to have it. That's what counts. It's to act upon it. Right? Because frankly, the actual rulings of how you do a fancy calculation uses an inheritance calculator. Like it's not a hukum ta'abbudi to calculate it as the ulama calculate it. It's nice if you can do it. I take a class with Sheikh Ali, he'll get very happy about teaching you how to do it. But that's not what matters. Right? That is like the masdar, right? It's not the iqa' al-fi'l, is al-hasil min-fi'l. It's not doing the calculation, but for your estate to be calculated. Say, I don't have much. Well, you have a couple of $1,000 worth of books. That's inheritance. Right? You have whatever you have. That counts as inheritance, right? Bismillah. Min thuluthi ma tarak, from up to 1/3 of what the deceased leaves. Yani, min ma tarak al-musi, of what was left by the one who specified in their estate, that in their will, that I have this fidya and this kafara to make. So basically there's a fidya for missed prayers, for every missed prayer, and there's a fidya for missed fasts, for every missed obligatory fast, and for other things that can be taken from up to 1/3. Now there's two cases. One is, if the person specifies it, then their will has to be fulfilled, but only from a third, because everything beyond the third is for the waratha. There's no right for the deceased over more than a third of their estate, right? Number one. لأن حقه في ثلث ماله حال مرضه, right? Because their right is in up to 1/3 of their wealth once they're sick. Or actually even from before, right? That you cannot specify in sickness, like you can give more than that to one of your inheritors before your final sickness. But ownership has to transfer to that person in their, during the lifetime before marad al-maut. But once you're in your final sickness, you can only apportion your wealth up to 1/3. Right? From marad al-maut. And then of course, once you're dead, you're dead. You can't do anything after you're dead. So once you're in marad al-maut, you only have disposal of 1/3 of your wealth. So in your final bed, you say, you know what? Oh, Hamza bhai, I really liked you. I never told you I did. So here's $10,000. And oh, Sheikh Faraz, I missed your classes, but you're kind of nice guy. So here's $2,000. And you could only do that up to 1/3 of your wealth in your final sickness. Right? Why? In order to safeguard the rights of the inheritors. Right? People live their whole life resenting their wife or their husband, say, well, I don't want her to get any money, I give it away to the dog shelter. Yeah, the dogs are more loyal than my wife, or whatever. Like people mumble, okay. It's not your call. Right? So even talaq during the final sickness, right? This is called talaq al-far or talaq al-firar, the talaq of the one fleeing. It has consequences. Anyways, وتعلق وتعلق حق الوارث بالثلثين, and the right of the inheritor, meaning the inheritors, right, was connected to the other 2/3. فلا ينفذ قهرا على الوارث. So their right, the right of the deceased, can their wasiyah فلا ينفذ يعني حقه, so their right cannot be fulfilled against the inheritors except for the third, which is within their own right. In awsa bihi, if the one who died had made a wasiyah for it. وإن لم يوصي لا يلزم الوارث الإخراج لا يلزم الوارث الإخراج. And if the deceased did not make any wasiyah, the inheritors don't have to give any fidya from the inheritance, because it belongs to them now. Right? It belongs to them. فإن تبرع جاز كما سنذكره. But if the inheritor, one, or the inheritors, all of them, choose to give willingly. So you could diagram this, right? That someone dies having to give fidya. If they made wasiyah, it can be given from 1/3. And not more, إلا أن يرضى الورثة. And from more than that, if all the inheritors agree. They can give for more than that, right? Person died, left an estate of $250,000, let's say. They had $167,000 worth of fidya to give. They gave their estate, 1/3 of 250,000 is how much? Hmm? 1/3 of 250? Come on, guys. What? 80 something? Like, come on. It's just numbers. What? Yeah, it's 83.3 thousand, right? So 1/3 would be 83,000. So the inheritors, so they gave wasiyah, please clear my fidya. That's only binding in 1/3. But the waratha can choose to give a little more, partial or full, but there's this pure tabarru', that's purely from them. And the ulama generally say, give a little more, but you don't have to do more than that, because they have rights, you have rights, and what we're seeing is something from the afu of Allah subhanahu wa ta'ala. And this is actually a real case. Happened with a friend of mine. Father died, hadn't prayed for decades, and then started praying and then died. Rahmatullahi alayhi. So I asked the ulama, they're willing to forego, they got moved because the father died when in his 50s, whatever, too much biryani kind of situation, right? So we'll give up all our. So I asked them, Mashayikh, what do you say? No, because they have rights too. Right? Like you have to worry about the dead, you also have to worry about the living, right? So I said, no, let them appoint a reasonable amount. One thing is to take the principle of 1/3, that the father didn't leave any wasiyah. Take from 1/3, if you want to do a little more, then a little more, right? But as we know from the hadith of Sayyidina Sa'ad, etc., right, that because leaving one's family freed of their needs and freed of poverty, etc., is also a governing consideration. And then one does the hilat al-tamlik that we will see. Okay. وعلى هذا, and on the same principles, and then, okay, so that's if the inheritor, if the person deceased left a wasiyah, then it can be taken from 1/3. If it goes beyond, it's not taken unless the inheritors agree. If he did not leave a wasiyah, did not leave a bequest, then there's no duty on the inheritors to give anything in wasiyah, but it's tabarru'. And that can be done by the inheritors, and it can be done by a third party on behalf of the deceased, whether related or unrelated. Right? Right? فَإِن تَبَرَّعَ جَازَ, and there's detail coming on that. And the same thing applies. وعلى هذا دين صدقة الفطر والنفقة الواجبة والخراج والجزية والكفارات المالية والوصية بالحج والصدقة المنذورة. And the same thing applies to zakat al-fitr, sadaqat al-fitr, and required nafaqa. Right? Required nafaqa is providing that you're required to do, i.e. by court order. Right? An-nafaqatul wajiba. Right? This is if there's qada of the qadi. Right? The nafaqa is wajiba. Right? But this is it only becomes a debt, the nafaqa, and if you reviewed, you'd remember this from Quduri when we did Ahkam it only becomes due if legally due. Because someone's supposed to provide $200 a month, that would be what would be entailed by his state and her background, but he didn't. 3 months later, auntie comes up and says, Maulana Umar ji, I did not receive 2 months of support. Does the husband owe her anything? No, because if she wanted support for September and October and he didn't give it, she should have asked for it. After the fact, he doesn't have to, because the support is for food, drink, and living, and she must have ate, drank, and lived. Because if she didn't, she wouldn't be here. Now, there'll be some moral culpability upon him, but retroactively it's not due. But if in court, like, because let's say he never provides for her, right? So in court it was set at a certain amount, then that becomes a debt that is due. And if they formally, and when it gets tricky, if they formally agreed to a nafaqah, then it becomes due, but diyanatan, and is it due qada'an? That's a separate matter. If they agreed that, look, I hear, so they're having a particularly if there's a dispute. Auntie and uncle got into a dispute, so Maulana Umar ji tells him that, uncle, can you agree to give $200 a month to auntie? Said yes. Says, do you accept that as your nafaqah? Yes, because they differ. Says, I like the asli ghee. He says, no, use this ghee, it's good enough. Says, get me organic eggs. He said, I can't pay for organic. He says, look, give her $200 a month, something that they both agree on, it's fair, and khalas, avoid the whole thing. I've provided $200, do with it what you want. Right? If it runs out, not my problem. So then that becomes a debt, right? A debt. These other things, kharaj and jizya and material kafaras, right? Material expiations, right? Like those related to Hajj, right? Or right? If someone was able to do Hajj but they didn't, so they made a wasiyah to do Hajj on their behalf. Right? Right? And there's fiqh related to that comes in Hajj. But the summary of it's mentioned by Imam Tahtawi, quoting the Tanweer. Is it quoting the Tanweer? Yeah. Right? Right? That, so someone can make wasiyah that someone perform Hajj on their behalf, and they have to pay for them from the asl is from their own hometown. Because that's not literally min manzilihi, meaning from their town, because that's what they would have spent on Hajj. Otherwise, from where it's facilitated, right? And that's also dispensation, right? Because let's say someone can't afford to pay for Hajj from here, but they could afford to pay for Hajj from Jordan, for example. Ultimately, it's under the lutf of Allah subhanahu wa ta'ala, right? And a sadaqah that you made an explicit vow for. But all of these are only taken from up to 1/3 of one's wealth, right? وَلِعْتِكَافِ الْمَنْذُورِ, and there's expiation also for the vowed i'tikaf. عَنْ صَوْمِهِ, but for the fasting, right? لَا عَنِ اللُّبْثِ فِي الْمَسْجِدِ, not for remaining in the masjid, because there's no expiation for that part. But someone vowed to make i'tikaf for consecutive days, then there's fiqh related to that we'll see in Kitab al-Siyam, right? So the fasting is assumed with the consecutive days. Someone dies by vowing to make i'tikaf for a number of days. Dimnan, within that, the fasting would be entailed, right? That's the asl. And we'll be seeing the details of that. وَقَدْ لَزِمَهُ وَهُوَ صَحِيحٌ, if these things were due when they were healthy. وَلَمْ يَعْتَكِفْ حَتَّى أَشْرَفَ عَلَى الْمَوْتِ, and they didn't perform i'tikaf until they're on the verge of death. كَانَ عَلِيهِ أَنْ يُوصِي لِصَوْمِ اعْتِكَافِ يُوصِي لِصَوْمِ اعْتِكَافٍ كُلَّ يَوْمٍ بِنِصْفِ صَاعٍ مِنْ ثُلُثِ مَالِهِ. For لِصَوْمِ, what do you have? Yeah, one would have to make the wasiyah for the fasting of the days of i'tikaf for each day, the same as the expiation for for a fidya for a missed fast, half a sa', right, of grain, etc., that'll be coming from up to a third of their wealth. وَإِنْ كَانَ مَرِيضًا وَقْتَ الْإِجَابِ وَلَمْ يَبْرَأْ حَتَّى مَاتْ فَلَا شَيْءَ عَلَيْهِ. But if one was already sick when they vowed, right, so someone in their final sickness said they vowed to perform Ertikaf for 10 days, but then they died. So they never had the ability to do it in a state of health to begin with, so no fidya is due. فإذا لم يفي به الثلث. Right? So in all these cases, if the third of their wealth is not sufficient, توقف الزائد على إجازة الوارث. Any more than this is dependent on the permission of the inheritors. Right? Right? And there's no expectation on them, right? It is up to their goodwill. Now, it's encouraged, right? So this is, if it's more than the third, to give a little bit, it's min al-ihsan, but that's really up to the situation. لِصَوْمِ كُلِّ يَوْمٍ طَعَامُ مِسْكِينٍ. One gives for the fast of each day, right? The feeding of a sick person. لقوله صلى الله عليه وسلم من مات عليه صوم شهر فليطعم عنه مكان كل يوم مسكين. Whoever dies, because the words of the Prophet صلى الله عليه وسلم, whoever dies and they have due upon them the fasting of a month, meaning the fasting of Ramadan, let them feed instead of it for each day a needy person. The hadith is in Tirmidhi and others. وَكَذَا يُخْرِجْ لِصَلَاةِ كُلِّ وَقْتٍ. And likewise, one would give for each obligatory prayer time, the prayer of, for each of the obligatory prayers, min fard al-yawmi wal-layla, of the obligatory prayers of each day and night, meaning the 5 daily prayers, hatta al-witr, and the witr prayer, because it's required. لأنه فرض عملي عند الإمام, because it's a فرض عملي according to the Imam. وقد ورد النص في الصوم. Now, here he is preparing an answer to the objection against the Hanafis. That the text has come about the fidya with respect to the fast, right? So the objection is, how could you make qiyas? Because the fidya is only established by the lawgiver, right? Because it's like a substitute, right? It's like a substitute. And you yourself keep mentioning this thing that substitutes are only established by the lawgiver, etc., etc. خَلَفْتُمْ أَصْلَكُمْ. And this is, of course, one of these shallow things. And my advice is, please, don't believe your enemy, not enemy, your opponent, right? The other party, the Shafi'is criticizes for something. Are they understanding it correctly? I said, okay, first go find out what do we actually say from our books. And some people, oh my God, they get existential kind. Imam, and the Shafi'i, and to be frank, the Hanafis aren't always fair with the Shafi'is, but the Shafi'is aren't always fair with the Hanafis. Even Imam Nawawi, who is such a balanced temperament, if you look at his Majmu', he's not particularly. And partly because the ulama of other madhabs struggle to understand our madhab, because our usul are so different and our reasoning is so different. So it is what it is. But Ibn Hajar is particularly unfair, because he had a lot of challenges with Hanafis in his time. So it's actually, there's a beautiful thing. Imam Anwar Shah al-Kashmiri said, I used to feel so bad. Yeah, he feels ghaira that Ibn Hajar is so fair with the other madhabs. Ibn Hajar is Shafi'i. He's so fair with the Malikis, the Hanbalis, but why is he not fair with us? Right? So he wanted to do some kind of refutation. Right? But he didn't feel that this is Ibn Hajar. So he spent years just. And then he prayed istikhara about it when he went to one of the blessed maqams in India. I forget which one. May have been Ajmer, may have been Khwaja Muhyiddin. But he went to one of the maqams of the awliya, and many of the ulama, this you can find in the biography of Imam Anwar Shah Kashmiri. So he went there and he prayed istikhara. And he had an inshirah of sadr. I forget whose grave it was, but it's one of the great awliya. And he had this inspiration that, look, address the issues that he talks about in Fath al-Bari, don't criticize him directly. Radiyallahu ta'ala anhu, right? So what's the objection here? Right? So this is that how could you make qiyas on this? So he says, وَالصَّلَاةُ كَالصِّيَامِ بِاسْتِحْسَانِ الْمَشَايِخِ. Right? So saying it's not qiyas. It's legal preference. It's istihsan. Right? Because the qiyas would be that la qiyas. The qiyas meaning النظر الفقهي الأول. The primary line of legal reasoning will entail there's no qiyas. Why? Because the fidya is a substitute for the actual action. It is limited by the conditions limiting it, etc., etc. So you can make qiyas. But this is legal preference from the ulama. On what basis? The basis being that, very simple, باستحسان المشايخ لكونها أهم, because the prayer is more important. That if you have to expiate for the fast, أول ما يسأل عنه العبد يوم القيامة, the first thing the servant will be asked on the day of resurrection is, of course, and what's understood implicitly is بعد الإيمان, right? Because people will be arranged according to their faith. But after that is the prayer. Number one. Number two, of course, there's another thing that the ulama don't really consider this to be an actual, like this is not a substitute, right? The fidya here, well, with the fast, we say, okay, the fast is like a substitute, right? It covers over. Here, yurja al-afu. We do this, the ulama encourage this, it's as an istihsan. Because one, the prayer is more important. Number two, is done in hope of Allah subhanahu wa ta'ala overlooking. Right? Right? And we know that, and this is a type of tawassul bil a'mal. Right? It's a type of asking Allah to intercede by actual actions, which is, whose basis is very clear in the, and there's many other reasons. This is the madhab, and people get tied up in knots about it. Say, look, this is our madhab. There are other opinions around. Like, you're asking us what our madhab is. This is it. What will people do with it? We try to explain it clearly, but then khalas. Lasta alayhim bimusaytir. You're not there to command over them, etc. Appreciate the position. Here it is. If you don't, barakallahu ta'ala fikum. Right? واعتبار كل صلاة بصوم يوم هو صحيح. And considering each prayer, you know, اعتبار كل صلاة اعتبار فدية كل صلاة, considering the fidya of each prayer to be like the fidya of each day is the more correct, is the correct opinion. وقيل فدية جميع صلاة اليوم الواحد كفدية صوم يوم. And there's a minority opinion that the expiation of every day of prayer is like the expiation of one fast. والصحيح أنه لكل صلاة فدية. But the sound opinion, he reiterates, due to the need for emphasis, the sound opinion is that the prayer of each prayer, the expiation of each prayer is نصف صاع من بر, is half a sa, half a sa is like a bowl, a large bowl, and a nisf sa works out to about how much?
2.2.
Yeah, they say 2.2, 2.5 if you want to be on the expansive side, right? Nisf sa'in min bur, half a sa of bur. What is bur? Yeah, of wheat itself, أو دقيقه, or its flour, أو سويقه. What's سويق? Where do you look up سويق? Sorry?
When it's ground up and it's technically fine.
What's سويق?
Or is it like porridge?
It's the ground up flour that still has some of the casings in it.
Are we shooting the breeze, or are we sharing a legal definition? Right? So there's two things, right? There's mafahim lughawiyya, but then there's the usage of the ulama, right? Right? So it's the السويق is الدقيق الذي لُت بالسمن, right? Is flour that has been, is dry flour that has been mixed with fat or with oil, and they do this to preserve it. Right? They do this to preserve it. Right? Because it wouldn't stay fresh forever. So if you put semen in it or the like in it, then it would stay for longer, right? It would stay for longer. So that's, so half a sa', about 2.25 kilos of wheat or flour, أو صاع أو صاع تمر, right? Or a full sa' of dates, أو زبيب, or raisins, أو شعير, or barley, because barley would be, because that's what's come textually. أو قيمته, or its material value, the material value of half of nisf sa', of half a sa', about 2.2 kilos of wheat. وهي أفضل, and this is better in our madhab, لتنوع حاجات الفقير, because the varied nature of the needs of a poor person, right? Then the basis of sadaqah is what's come about sadaqat al-fitr, أغنوهم عن المسألة, free them of the need to ask, right? And the faqir, yani the underlying basis of sadaqah is معنى الفقر الذي هو الاحتياج. And the reason you give to the poor is because they're needy. So you're giving them because they're needy. So what do you give them? That which helps cover their need. So that which better covers their need is superior. So in our madhab, if you're sitting on 2 piles of wheat, and you could give it to someone who'll use it, unless this is more beneficial for them, it's better to give the actual money in our madhab. And they say, except إلا في زمن قحط حيث كان يعني كانت العين أنفع, except in a time of drought, for example, where the actual wheat or flour would be of more benefit, right? I don't know if this is, I don't, right? And right? Now, you give it to a poor person who's, someone who has a sifa of faqr. There's an issue which is you have to be careful about feeding a poor person. Because how do you feed a poor person? How do you feed a poor person? How would you feed a poor person? Let's say you're going to give food.
It has to be tamleek.
Yeah. So ultimately there needs to be tamleek. The danger is, and this happens particularly in some developing countries, right? They say, okay, let's go to the village and take a big pot of biryani or take a big pot of food, and then there'll be. But legally, what is the status of the rice? So I'd been about to order pizza, but let's say if I ordered pizza and say, okay, let's eat from this pizza. You took a slice, who does that slice belong to? It doesn't belong to you. You just have ibaha. It's been permitted for you to eat. So tamleek didn't really take place. Unless you, for example, put it in boxes and you distribute boxes, say this is for you, or boxes or whatever. That's safer. So that's the other thing. In feeding, it can get messy, right? Some people go to like a shanty area, like a shanty town or a slum, and say, and let's feed people. It's better to put it in containers, because then there's tamleek. Because just them coming and taking is a bit more problematic. And there's fiqh related to that. You can find it in its places. Okay. وَإِن لَمْ يُوصِي. Now, if the person didn't make a wasiyah at all, right? وَتَبَرَّ عَنْهُ وَلِيُّهُ أَوْ أَجْنَبِيٌّ جَازٍ إِنْشَاءَ اللَّهُ تَعَالَى. Right? And this أَوْ أَجْنَبِي, right? There's some khilaf mentioned in the madhab, because some took it textually, right? And sometimes the fuqaha, you have to, some say, okay, if the wali did it, okay, mafahim al-kutub hujjah, the indication that if their inheritor gave wasiyah, it'd be valid. The implication would be if someone else did, it wouldn't. Not necessarily, right? So that's why the ajnabi is mentioned. A friend, a family, the neighbor heard the person, they overheard the conversation. Whoever. If they didn't leave, what temperature is it on? Could you just check what temperature it is? Okay. If they didn't leave a wasiyah themselves, the deceased, and their inheritor or a third party gave of their own accord on their behalf, it's valid. Insha'Allah ta'ala, Allah willing. لأن محمدا قال في تبرع الوارث بالإطعام في الصوم يجزئه إن شاء الله تعالى من غير جزم. Because Muhammad, meaning Muhammad ibn al-Hasan, said when describing the inheritor feeding giving, feeding the poor in order to pay the fidya for missed fasts, it would be valid, Allah willing, without jazm. Because you don't say, in fiqh you don't put Allah willing. Right? You don't answer a person's question by saying, Insha'Allah. Because you didn't answer the question. Either you know it, so you respond, or you don't, then say, I don't know. When you're sure you know the answer, you put Wallahu subhanahu wa ta'ala a'lam, right? Something like that. And Allah knows best. But that's not a speculative Allah knows best. Right? That's min bab tafweedi haqiqat al-amr ila Allah. Right? Right? وفي إصائبه جزم بالإجزاء. But Imam Muhammad al-Hasan, when the deceased person left it in their will to feed, and this is with respect to the fast, he was firm that it counts because of the textual evidence, because it's textually established. And so meaning that this is something that the living, part of their living will is to keep track of what you owe Allah subhanahu wa ta'ala and what you owe people. You should keep track of that. Right? One should have like a practical living will. Right? So it's not just a portioning of inheritance, but what you owe people and what you owe people, and number two, what you owe Allah subhanahu wa ta'ala of missed duties, so that, and either a living will should have all the details in there, or you should appoint, and people, if you appoint people, it's useful to have, this person, in their absence, this person, in their absence, this person, or their equivalent, right, of someone with these characteristics, so that you can be sure that it be discharged properly. وإذا تبرع أحد بالإعتاق عنه لا يصح لما فيه من إلزام الولاء على الميت بغير رضاه بخلاف وصيته له. But if someone chose to free a slave on behalf of the deceased, this is not valid. Why? Because if you do it on their behalf literally, then it would entail that the wala, the responsibilities of the social protection of the freed of this free person accrue to the deceased and thereby to their family. So the neighbor comes, I'm freeing a slave on your behalf. The person has died. So now, if it literally were to count, then the responsibility to transfer the inheritance, they didn't agree to it. The deceased didn't agree to it, nor did they. But one can free a slave and donate the reward of it. The reward, because it's one of the highest of matters, right? وَمَا أَدْرَاكَ مَا الْعَقَبَةِ. What is the highway? First step on the highway is فَكُّ رَقَبَةِ, freeing the slave. بِخِلَافِ وَصِيَّتِهِ بِهِ, as opposed to if the deceased made wasiyah for a slave to be freed, whether it's a slave that they owned for them to be freed, or that for a slave to be purchased and freed, purchased and freed upon purchase, that would be valid, i.e. from up to a third of their wealth, right? And then he says, وَفِي الْوَصِيَّةِ بِالْحَجِّ يَحُجُّ مِنْ مَنْزِلِهِ مِنْ ثُلُثِ مَالِهِ. Right? And in the wasiyah to perform hajj, like someone who had to perform hajj and fulfill the conditions of obligation, but didn't get around to, right? Or they requested a nafil hajj on their behalf, and we'll look at the fiqh related to that. The basis is that the hajj would be paid for from the menzil from the home, in the hometown practically, of the deceased. Right? If, and this is the optimal, and he reiterates, right? In kafa, if there's enough. وَإِلَّا فَمِنْ حَيْثُ يَكْفِي. Right? Or otherwise from where the money would be enough. Right? Even if one from another land. Right? And we took that. وَالْمُتَبَرِّعُ بِهِ مِنْ حَيْثُ شَاءَ سَوَاءٌ الْوَارِثُ وَغَيْرُهُ. And if someone's voluntarily doing the Hajj on behalf of the deceased without their wasiyah, they can do it from wherever they wish. Whether it be the inheritor or someone else. They know that their uncle was a wealthy man, but he never did Hajj. They want to do Hajj on their behalf. They don't have to do it from there. Like, they could do it themselves, or they could pay for someone to do Hajj on behalf of their uncle. And the hope is that this cover over, right? Inshallah. Yujzi, inshallah. ولا يصح أن يصوم الولي ولا غيره عن الميت ولا يصح أن يصلي أحد عنه. It is not valid, actually not permitted either, to fast, whether it be the guardian or anyone else on behalf of the deceased, and it's not valid that one pray on behalf of the deceased. لقوله صلى الله عليه وسلم لا يصوم أحد عن أحد ولا يصلي أحد عن أحد لكن يطعم عنه. Because of the hadith of the Prophet ﷺ, he said that no one may fast on behalf of another, meaning no one can fast, perform the fasts of another, nor can any pray the prayers of another. Rather, they feed on their behalf. That's understood to be the fidya. Right? And of course, there are a number of these hadiths that indirectly point towards the ruling of the fidya in our madhab. Right? As well. Not just from the hadith of the Prophet ﷺ, right? And this is amongst them, right? So some people say there's no evidence whatsoever. Said. And sometimes some Hanafis say, I was reading the Maraqi, I was like, people read things so shallow, it's like it's staring at you in your face, like if so I didn't find it, if it came to you with a hammer and hit you on the head, you wouldn't notice it. Right? So when they say there isn't an explicit, there's a difference between an explicit text, which is explicit saying, do this, right? But there's a number of texts that indicate that meaning. There's a whole bunch of them. Amongst them, this hadith, and of course, some of the texts reference this to An-Nasa'i in the Sunan al-Kubra. Now the Sunan al-Kubra is not the Sunan that is in the Kutub al-Sitta. It's a larger work of Imam Nasa'i, also one of the great works of hadith. But it's much larger than, it's called known as Sunan al-Sughra or the Mujtaba. Right? When we say Sunan Nasa'i, what's meant is the Sughra, not the Kubra. Right? Because like many muhaddithin, he wrote more than one book. Okay. وما ورد في قوله صلى الله عليه وسلم من قوله صلى الله عليه وسلم فصومي عن أمتك وقوله صلى الله عليه وسلم من مات وعليه الصيام صام عنه وليه فمنسوخ كذا في البرهان وغيره. Right? As for what's related from the words of the Prophet, so fast on behalf of your mother, right? Which is related in Bukhari, or the words of or his words sallallahu alaihi wasallam, whoever fasts and they have fasts due, their guardian fasts on their behalf, and these are also in Bukhari and Muslim. This is abrogated as mentioned in the Burhan, Sharh Mawahib al-Rahman of al-Tarabulsi and others. And very often al-Burhan takes this kind of reasoning from Fath al-Qadir as well, right? That's one. The other is mansukh. Of course, legally establishing naskh is a big claim, but you need that mansukh, and this the Hanafis use this from the earliest. The mansukh is that its madlul is not taken on its outward implication. Right? Mansukhun fi madlulihi. Now, is there actual naskh? That's a bigger argument. But even it's confused in the writings of al-Tahawi, says this is mansukh with this, and say how? And they get all caught up and tied in a knot. Even actually Alam al-Laknawi, he gets upset several times with al-Tahawi about this, but they're not talking about that kind of naskh, right? Of the usuli naskh. It just means that what is indicated by this is limited in its madlul by this. Did actual naskh, actual abrogation take place? That's a separate matter, right? That's what's meant by al-Karkhi's words, كل نص خالف مذهبنا فمنسوخ أو فمؤول أو منسوخ. Any text that goes against our school can be explained or is abrogated. But it's not there. Does not mean mansukh in that way. Meaning it's madlul. Abu al-Hafs al-Nasafi has a exceedingly brief explanation of the shawahid. He gives examples basically to the usul of al-Karkhi. I think it's recently been published through much fanfare. That awwal marra, it's been published for ages, but not in a pretty modern edition, but it's been floating around for ages. There's some beautiful manuscripts around about it as well. Anyways, the other explanation is fast an ummiki, fast meaning very simple. Because how do you understand these texts in light of those? Is fast on her, meaning fast, and this is min bab ihda'i thawab, and it's laysa min bab يعني أداء عبادة الميت, right? This is from fasting and donating the reward of your fast to the other person, praying and donating the reward of your prayer to the person. You can do that, because as Imam Ibn al-Humam put it, because there's a lot of discussion, he goes, the basis is that anything a person can do for oneself, one could donate the reward of it to any other or to the whole ummah, right? Any other, past, present, or future, right? And it's a type of making dua. Can you make dua? Allahumma yani athib ummata Sayyidina Muhammadin sallallahu alayhi wasallam thawaban amman. Allah grant reward to the whole ummah of the Prophet sallallahu alayhi wasallam. Can you say that? Yeah. Then why can't you say, give every one of the ummah of the Prophet sallallahu alayhi wasallam 10 rewards? Now, at the end, you can't sit there as an account. Oh Lord, did you do it? Because you're a servant, you're a slave, you don't have a right of demand. But you can just ask Allah to grant reward without doing anything. Here you did something sincerely for Allah, and say, oh Allah, I ask you to grant the reward of it. Right? And the issue of ihda' al-thawab, a lot of people don't understand. One of the really solid answers on that, Sheikh Faraz Khan's answer on seekers, is really good. Like, you'll be hard pressed to find something as good as that in one place in Arabic, right? It's very well done. And so he says, فَمَا يَفْعَلُهُ جهلة الناس الآن من إعطاء دراهم للفقير على أن يصوم أو يصلي عن الميت أو يعطيه شيئا من صلاته أو صومه ليس بشيء. So what some ignoramuses do in our times of giving a little bit of money, darahima, this it's plural, right? But it's tankir, some dirhams, and a little bit of money to some poor person to fast or pray on behalf of the dead, or to give them something of their prayer or fast, like donate the reward of somebody for your prayer or fast, right? Is laysa bishay, is of no consequence, right? وإنما الله سبحانه وتعالى يتجاوز عن الميت بواسطة الصدقة التي قدرها الشارع كما بيناه. Rather, Allah Most High overlooks, meaning يتجاوز رجاء لا قطعا, right? يتجاوز يعني رجاء منا وفضلا منه, right? Out of hope from us and bounty from him, right? Through the charity that has been specified by the lawgiver in the way we have explained. وإن قلنا بأن للعبد أن يجعل ثواب طاعته لغيره فهو غير هذا الحكم فتنبه له فليتنبه له. And if we say, as we do, right, that وإن, this is wasliya, that and even though, right, it's not if meaning and even though. That's why al-Tahtawi explains it. The in here meaning even though, right? And it's an answer to an implicit question as well. And even though we do say that the servant can make the reward of their acts of obedience to other than them, and of course when you donate the reward, it's conditional on sincerity, which is why you can't hire someone to donate reward to someone else, because that's not even sincere. Number one, it's conditional upon sincerity. And number two, the person is not foregoing their reward. إِنَّ اللَّهَ لَا يَضِيعُ أَجْرَ مَنْ أَحْسَنَ عَمَلًا. Right? So this donating of reward is a type of dua and tawassul bil a'mal. Right? It's dua and like a tawassul through one's actions. Right? So I said that's a different ruling. Right? Because the qada and the fidya, the make-up, and in the absence of ability to make up, the expiatory payment is إبراء ما في الذمة, is to clear what is in the person's due, right? So there's debts owed to Allah subhanahu wa ta'ala in the person's dhimma, right? The issue of fidya is how does one expiate and thereby take those out from the dhimma and maybe put in some good deeds with that. Donating reward, but that what's in the dhimma, this is in the section of fard, right? So the container has a core element. That's what you look at first. What do you have? Have you fulfilled your obligations? And you have debts due. And then there's the good, right, around it. So it's almost like a two-chamber container. Obligations, fulfilled, due, right? The fard, the huquq. And then there is the nawafil, the extra. That's why I say it's from madness to do the nafil and to leave the obligations. إهداء الثواب is nafil, right? Granting reward is from nafil. It just, you ask Allah to put extra into someone's wi'a. That's fadlullahi wasi', right? So we'll finish this section. We're almost done. At the beginning of next class, this is the hilat al-isqat. There's a legal way that if there's not enough to clear the due, one can take there's a legal way of dealing with it, and then we'll look at how one makes up one's missed acts of worship, missed prayers when brief. So we ask Allah subhanahu wa ta'ala for ease and assistance and facilitation. Wa sallallahu ala Sayyidina Muhammad wa ala alihi wa sahbihi sallam walhamdulillahi rabbil alameen. And this hila of isqat, the hila of isqat al-fidya, how it's done, is described in a very structured, systematic manner in the Hadiyah al-Ala'iyya. Right? And you do well to complement that there. وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم والحمد لله رب العالمين.